And probably the biggest one is, how can they do such a thing at a time like this? Obviously, we're in unprecedented times, and here SEVP, which is a subdivision of Immigration and Customs Enforcement, which probably tells you a lot, which is a subdivision of the U.S. Department of Homeland Security, has dealt up this new policy with very little notice to the general public. So first of all, the question comes, can this be done? And the answer is, this is an administrative policy, and policy regulations can be implemented by the executive. Really, it becomes a question of whether or not this should go through the formal rulemaking process as is laid out under the Administrative Procedures Act. So that's something that, of course, is ripe for litigation, and something that we're maybe going to see happen, namely litigation, within the next several days or even several weeks. How does this policy impact Indian students? Well, basically, those Indian students who are at academic institutions where they're all of a sudden going to a full online program are going to need to make immediate adjustments or accommodations. And so the first way in which they need to look at it is that they may need to start looking at other programs where there are not, where the program is not 100% online. Of course, what we would strongly recommend is that anyone who's affected by this policy immediately reach out for DSOs or ISOs at their academic institutions if they're affected by this, and to speak to them to see whether or not some type of an accommodation may be made to the academic schedules in the universities and the colleges, so that they would be able to circumvent this policy, which means basically that the program is not going to a fully, a full online program, but that maybe there's some adjustment that can be made for international students, so that part of their program would be able to be done by way of an in-person with social distancing type of an accommodation. Next question that we're getting is, of course, is it legal for them to do this? Well, again, it probably is legal from the perspective that the executive has the ability to promulgate regulations. However, and as we know from the recent Supreme Court decision upholding DACA, we know that where DACA was allowed to be able to stay in the law, the Supreme Court justices focused on the fact that there was a violation of the Administrative Procedures Act, and also there was big focus on this issue of what's called forbearance. And so we can see these two issues really coming to the forefront also in the event that some type of a challenge by way of a restraining order would be brought, under the circumstances for this particular rule. We believe that this policy may have its genesis in the development or the roots of the SEVIS, which obviously found its way into the law following 9/11. So it's our guess that the government is going to use some kind of a national security type of argument to defend its ability to implement this type of a program. Our attempt to do workarounds for this type of a policy will be to discuss with academic institutions and with their higher ups the possibility of implementing some type of an accommodation schedule, or probably a number of credits that might be available to international students through in-person education, so that they can circumvent the rigidness of this policy. So yes, we were definitely dealt up a surprise. Certainly, what we see here is a situation where, pardon the expression, but we were kicked while we were down, and we are going to work with our professional organizations, along with the National Association of Foreign Student Advisors, and also along with the American Immigration Lawyers Association, to see what we can do to circumvent the onerousness of this policy. Hello, my name is David Nachman, and I'm one of the managing attorneys at the NPZ Law Group, Nachman, Fawani, Zimochek, and we have offices located in New Jersey and also in New York.